And now to our interview segment. Some of the happenings of the past week are still talking points even as the events surrounding them continue to unfold. My guest, Mr. Onigbanjo SAN, has very strong views about the situation with the judiciary in Ekiti State. He says there's an urgent need to prevent a slide into anarchy. We also talked about the situation in Adamawa State and explored the likely outcomes of the appeal on the governorship seat. Let's start with one of the issues in the news, the recent judgment of a Federal High Court Abuja that returned the former Deputy Governor of Adamawa State, Bala Ngilari, back to office. It has continued to, generate reactions, but what do you make of the judgment?
Well, the decision is very interesting. Firstly, because it reinforces that, to an extent, the rule of law still applies in our country, given the context of what has happened in other states regarding the attitude of the executive to the judiciary. It was very refreshing and very pleasing to see that that judgment was obeyed instantly by all concerned, and given effect to. I think that in itself is a very commendable aspect of the judgment. I believe, firstly, that any judge, any court, should be permitted to give judgment in any matter placed before him, wrongly or rightly. One of the rights of any judge is the right to even make mistakes, and where mistakes are made, you can go to the appellate courts. There are two, there are two levels. As the acting governor, who has been removed by the order of the court, as he has rightly indicated that he would appeal the decision. That is the way it should be. Now, to the merits of that judgment, I have looked at the constitutional provision myself, section 306, subsection 1 of the Constitution. It clearly says that for the resignation to be effective, the letter of resignation should be submitted to the person who appointed that officer or the person who elected him. Now, in the case of a deputy governor, who appointed him, the governor. So his letter of resignation should be transmitted to the governor. And where that has not been done, as was found in this case, any other letter to any other authority, the resignation letter is of no effect.
Now, you alluded to the fact that the former acting governor, the speaker now, has, appealed the judgment. Don't you think that there will be a constitutional crisis if he wins, given the fact that his original term of 3 months, he just has a week left to spend before it expires? Can his tenure be extended, if the Federal High Court finds that, his appeal has merit? What would happen? Because some people think that there will be a constitutional crisis if the appeal courts return him back to office.
I really do not think there will be a constitutional crisis. The worst that would happen would be that let's assume it will get to the Supreme Court. The Supreme Court will say the resignation, let's assume the Supreme Court says the resignation was valid and he was therefore acting validly as the acting governor of the state. They will simply say, go and complete your term, right? And then thereafter, elections will be held. So I do not see how there will be a constitutional crisis. We've had that kind of situation before in your state. When Ladoja was impeached, he went to court. It took him maybe a year or two, eventually, before the Supreme Court ruled in his favor. He was returned into office to go and complete the remainder of his term. So I really do not see it resulting in any constitutional crisis.
When you consider the fact that he has just a week to go before his tenure expires, if he's returned back to office and INEC cannot conduct elections within a week, then what happens?
The situation will be, if they say that, okay, the resignation was valid, you are the validly appointed acting governor of the state, and the lower court was wrong to have removed you, go back and go and finish your tenure,
which is just 1 week.
Which is 1 week, and then elections hold. If INEC cannot conduct the elections within 1 week, the Constitution also provides for that kind of situation where you simply have the speaker, whoever the speaker is, stepping in to be the acting governor until any time that INEC says it is ready to conduct the elections.
So he goes back to office, uses the 1 week left of his term.
Yes, yeah, he only has 1 week.
Yeah.
And I can foresee that, you know, one of the arguments that he would meet at the appeal court will be that, look, your appeal is academic, you know, because you have 1 week. But again, even if it is 1 day, it is a right which, you know, is entitled to pursue.
Some people have said that perhaps it's time for the country to take another look at, you know, the laws guiding impeachment, especially when you consider the fact that it's now being used as a political weapon, a weapon of blackmail, like we saw in this case where the speaker sacked his 2 bosses and became a beneficiary of, you know, the outcome. And when you consider the fact that there's no specific definition of what constitutes gross misconduct, do you think that we should be looking at reviewing the laws that guides impeachment in the country?
You see, I always am very reluctant to jump on this bandwagon. Anytime we have a crisis, we think maybe our laws are defective. The major problem that we have are the operators. Because I can tell you, if you amend these laws, I can bet that the operators would also create a crisis out of whatever amendment you seek to make.
They'll still look for the loopholes.
So yes, they'll still look for loopholes and exploit it. But you know, the situation as it is now, the provisions as they are right now, they provide for adequate checks and balances. Let's say you have a very ambitious speaker who wants to remove the governor and the deputy governor. Now, he submits the impeachment notice to the chief justice, to the chief judge of the state. That chief judge independently sets up a panel to look into the impeachment notice. So let's assume the speaker is ambitious and you know, fabricates or manipulates this process. What about the CJ? That is why the CJ,
that's an appropriate check.
Exactly, it's a check. So the CJ, if the CJ really sets up a panel of independent-minded persons who have no political, you know, affiliation to any of the parties involved, they will look at it dispassionately and throw it away. That was what happened in Nasarawa State, for example. The State House of Assembly were hell-bent on removing the governor. They submitted the notice to the chief judge. The chief judge set up a panel, and the matter ended there. So it's not as though it is always a smooth sail for the ambitious speakers, in quote. But nobody would deny that it acted as a check on the State House of Assembly, because the State House of Assembly themselves can be accused of not being independent, in that the man was not a member of their party, and they wanted somebody in their party to take over the reins of power. So that's why you have all those different officers with different roles to play. Now, take, for example, another scenario that could have played out is the CJ chooses a panel. Even that panel is not beholden to the CJ. It doesn't have to do the CJ's bidding. It doesn't have to do the State House of Assembly's bidding. So again, even that panel can also act as a check, even against even the CJ, where even the CJ is, you know, is let me say, playing along with them.